The live stream will begin shortly. Please note that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of the show are not attorneys. RapidVisa is a document preparation firm, licensed and bonded in the state of Nevada. We will do our best to answer informational questions during the stream based on our experience in helping tens of thousands of customers successfully apply for their immigration petitions. However, if you need legal advice, we advise you to seek assistance from an attorney. Please post your questions in the comments section during the stream for a chance to win a $100 RapidVisa credit towards a future service. Now, enjoy the show.
Hello everyone, Rick Whitaker here with RapidVisa. Welcome to a special edition of our live immigration Q&A, now streaming on YouTube, Facebook, and Instagram. Today our CEO, Ben, is joining us from Cebu City, Philippines. Welcome, Ben.
Good morning, everybody from the Philippines. It's 6:30 in the morning. All's well. Before we get started here, we want to kick off as we always do. We have a $100 credit to in for any RapidVisa service that we'll randomly select from the comments at the end of the broadcast. So if you may be or maybe using our service in the future, certainly get your questions in there and be eligible to get that $100 credit. But whether or not you're interested in the credit, or please send your questions, enter them in the comment section or whatever site you're on, and we try to get to all of them. We limit this thing to 1 hour, so if you think you have a question, I can get it in there quick so we can get to it. And with that, let's jump right in. Do we have a question?
Yeah, I'll start off with one of our FAQs, frequently asked questions.
The live stream will begin shortly.
What's the difference between immigrant and non-immigrant intent? The type of visa is determined by the purpose of the travel to the United States. An immigrant visa is for someone that wishes to immigrate to the U.S. or permanently live in the United States. Whereas a non-immigrant visa is issued to a person that wants to come to the United States on a temporary visa to visit the United States, to be a tourist, or for medical reasons, maybe a business meeting, coming to a conference, temporary work, or study is some examples. The one thing I wanted to point out, though, is with the K-1 Fiance Visa, it's sort of a hybrid visa, if you will. It's a non-immigrant visa, but it's treated or processed like an immigrant visa. So with a Fiance Visa, a foreign fiance can come to the United States and marry their U.S. citizen fiance within 90 days, and after they marry, they can file for adjustment of status and get a lawful permanent resident status and then become an immigrant. So I just want to point that out when you mention the difference between non-immigrant and immigrant visa.
Yeah, right. You know, the terminology gets a lot of people. Unless you're doing this all the time, it's easy to get confused between visa and passport and immigrant and non-immigrant and green card and all of those things. So we're always happy to answer those kind of questions. But basically, to summarize what Rick just said, an immigrant visa is a visa for a person who intends to immigrate, and the word immigrate really means to live here permanently. So that, that's in plain English, that is, you're coming here to live. That's an immigrant. A non-immigrant is you're coming here. I say here, I'm actually in the Philippines right now, but you're coming to the United States to visit for some reason, business, personal, medical, sporting event, go to school, whatever. If your intent is to be in the United States temporarily, now temporarily, as in the case of a student visa, could be years. You might be here 4 or 6 years working on a bachelor's degree or master's degree, but that's still considered a non-immigrant visa because it doesn't get you permanent residency in the United States. Okay, I have a question here from Curtis. I think I got the name right. Can my fiance visit me in the USA with a tourist visa while we wait for our NOA2, and will our paperwork have any delays or troubles if I change jobs. Okay, so he's asking, obviously he's filed a fiance visa, that's a K-1, and he wants to know, it takes a while, so he wants to know if his fiance can come visit him. Very common question, while he waits on the NOA-2. NOA-2 is the approval from the CIS. So these terms, NOA-1, NOA-2, it's really just slang. Those aren't official terms, but what it means is notice of action. Notice of action 1 would be your receipt notice saying they got a receipt that your petition was filed. And then the NOA-2 typically is going to be the second notice of action received, and it's usually, you hope, is the approval. It could also be a denial. NOA-2 could. So anyway, back to the question. The short answer is yes. There's no rule or law that says that you can't come on a tourist visa while you're waiting on it. But the real answer is no. Most likely you're not going to be granted a tourist visa. If they see that you have a pending K-1 visa, they're just almost certainly, or any kind of pending visa, pending immigrant type visa, they're almost certainly not going to give you a tourist visa. But if you already have one, most tourist visas in most cases are good for 10 years. So if you're frequent visits over the course of 10 years, if you already have a valid visa, I mean, we see it a lot from Canada, fiance, and you didn't say what country you're in here, but your fiance's in Canada, they have easy access to cross the border. Can they come visit you while you're waiting? Yeah, absolutely, you can. If you already have a visa, you can do it. The problem becomes, you could be denied at the border. We've seen that happen. We don't have a good grip on how often it happens because we basically usually only hear from the people who had problem got denied at the border. But the CBP guy at the border, Customs and Border Protection, when he looks up your ID and he sees in there you've got a pending case, if he suspects you're actually trying to shortcut the process, because he already knows, because you've got a pending visa, they already know your intent is you want to live in the United States. They already know that. And so if he suspects that you're trying to shortcut the process and just come over and abuse your tourist visa to stay here, that you can be denied at the border, and we have absolutely seen it happen. You could fly in after your long, 12-hour flight or 22-hour flight if you're in Asia or whatever. You show up, they can turn you right around. They put you in a holding room and put you on the next flight out and make you leave at your expense. So, and it has happened. It's not mythology. We do see it happening. Does it happen often? No, we hear of it a few times a year, but that's just the ones we hear of. So if it was me, I wouldn't do it. If you can drive, I mean, if you're in Canada, if you're in Toronto and your fiance's in New York or Maryland or something where, it's not going to be a significant burden if you got turned away at the border, sure, give it a shot. You're not breaking any law as long as you're honest with everybody when you try to enter and all that. But if you're going to have to go apply for a tourist visa, buy a plane ticket, come all the way over here, I wouldn't risk it based on what we've seen. Our experience is. But if you want to try it, again, you're not breaking any rules or laws. But our experience is it's probably not going to be a good idea. Better though for you, the U.S. citizen, of course, can go visit your fiance all you want. And so, if you'd like to see each other, of course, the wait is horrible. My advice is for the U.S. citizen to jump on a plane or drive, whatever the case is. And I would do it that way. That's my best advice. But if you want to try it, good luck. Okay, let's move along. I'll let Rick grab the next one.
All right. LaDonna Nicholas asks, we are on the National Visa office. I'm assuming you mean at the National Visa Center stage. Says, how long will it take before the next step? And are we getting closer? And how much will the physical test cost in the Philippines? We'll start off with the first question. How long will it take? It really depends on which type of a visa you're filing for, if it's a fiance visa or a spousal visa. If you're staying at the National Visa Center for a period of time, I'll assume it's a spousal visa because usually the spousal visa can take anywhere from 2 to 3 months. What the National Visa Center is going to do after you get approved through the USCIS, the National Visa Center will collect all of your financial documents, your affidavit of support. They'll collect your civil documents. And then once they've collected all those documents, then they reach out to the U.S. Embassy there in Manila, and they'll schedule an interview appointment. Once you schedule the interview appointment, then you'll want to make sure you complete the medical exam at least 5 business days prior to the interview to allow St. Luke's Medical Center enough time to transport the medical report over to the embassy and the consular officer. You ask how much the medical exam costs. Right now, it's you're looking at about between $200 to $300 US dollars. And that would be paid in local currency. It'd be paid in pesos, and it's paid directly to St. Luke's Medical Center, which is just down the street from our office and just down the street from the U.S. Embassy. If you were looking at a fiance visa, though, you're only looking at it a matter of weeks, because with a fiance visa, the only thing a National Visa Center does is assign a case number to your fiance visa, and then the fiance visa case, and then they forward it on to the embassy. But if it's a spousal visa, it takes a little bit longer because they do have to process all the documents. And if it is a spousal visa, you should have received an invoice. You have to pay the fees online, and then they give you a cover sheet and instructions on how to send everything in. But hopefully that answered your question. And we'll move on to Ben now.
Okay, live from Cebu City in Visayas. I got a question here from Freddie. He says, I read that a Vermont immigration has got into trouble for money fraud, and they're trying to temporarily suspend it. If that happens, will all those cases go to the other immigration buildings? So will that slow down my K-1 visa petition? Okay, Freddie. Sounds like what you're saying is Vermont Service Center has some money fraud issues. I haven't heard that. I'm surprised, but however, I have been traveling, and so maybe I've missed that. But bottom line is, yes, anytime we do see problems at certain centers sometimes, the 2 primary things we see are weather, in the case of, say, hurricane type issue or a blizzard. And then, of course, we see workload issues. And in both cases, if there's a problem at one center, they'll change it to another. So, yes, there are many USCIS centers throughout the country. And it seems I don't know the details again of what's going on, this money fraud thing you said. Sounds like maybe there's some fraud. Every once in a while that does happen. You'll hear about people taking bribes or some kind of nonsense going on at an embassy or a USCIS center in the U.S. Typically, they deal with that locally. They root out the people and they don't stop or suspend operations. And I would imagine that's what would happen in this case. However, if for some reason it was systemic or bad enough that they thought they needed to temporarily stop processing, yes, based on the experience that we've seen, they would just ship those documents to one of the other processing centers to be handled, your petition. So the second part of your question is, will that slow down your case? Well, yeah, almost certainly it would. Now, it's not going to double the timeline, probably. I mean, there's a lot of variables, like how busy is the center they're sending it to, how competent is that center at doing K-1s. I mean, if they send it to Nebraska, where they normally don't do K-1s, maybe they're not quite as competent at doing them. That could mean it takes them a little longer. So a lot of variables there. Hard to know how long it would take, but just kind of based on our years of experience, I would say it would add a month or 2 to your processing time. I would not expect it to double it. But again, I'd be surprised if they shut down the whole center. It would have to be, they would have to feel like, a significant part of the staff is doing things that are illegal or suspect. It's more likely that they would isolate the problem to certain individuals and then keep on going. I think that's what would happen. So, thanks for pointing that out. I hadn't heard of it. I'll go do a search and look into what you're talking about. But it's not that uncommon. It seems like maybe once a year or so you hear about somebody at embassy who's taking bribes, or somebody at the U.S. USCIS office in the United States who's involved in some shady dealings. So no surprise, it definitely happens. But it would be a surprise if they shut down the entire operation for it. Okay, I'll kick the next one back to Rick in Las Vegas.
Thanks, Ben. Kelsey Burris asks, if we started the process in August of last year, 2017, for the K-1 fiance visa from the Dominican Republic, the last thing we heard was that USCIS had sent the docs over to the National Visa Center, and we haven't heard anything since. You know, Kelsey, the first thing I would do personally is I would call the USCIS to confirm that they had sent the documents. You can also check your status online. If you have your case number, you can find your case number on your I-797 Notice of Action letter. You should have received that as soon as the USCIS received your case. And then once the USCIS approves your case, you should receive a second letter, and that's called the I-797 Notice of Action number 2, also the approval notice. And since you said they sent your documents on to the National Visa Center, I assume you received your approval notice. But anyway, on that letter, you will have a contact number. Call the USCIS, just confirm that it did go on. You can also call the National Visa Center and ask them if they received it. But at this time, I mean, since August of last year, we were talking almost 12 months now, you should have heard something. The MVC should have assigned a case number to your petition, and then they should have sent it on to the U.S. Embassy. And but basically, I don't have much more information other than that, and the only agency or department that can give you that information is the departments who were had your case at the last point. You may even be able to call the U.S. Embassy as well, but I would probably call the USCIS and National Visa Center first, because the U.S. Embassy is going to ask you for the MVC case number. And if you don't have the MVC case number, I highly doubt that the U.S. Embassy would be able to give you much information on that. So back over to you, Ben.
Okay, looks like we've got a question from Arvin. He says, what's the next step after the USCIS received our intent to marry letter RFE? So I'm going to assume then that you're filing a K-1 fiancee visa, and you filed it and you got an RFE because you did not include an intent to marry. So, or a letter of intent. Okay, so the answer there is typically when you get an RFE, typically they've looked at your entire case and they will list everything they found wrong with it. So typically, and there's always going to be exceptions, but typically, and in most all cases, if you get an RFE, that's the only thing they found wrong. In other words, if the whole thing was a disaster, they would have sent the whole thing back to you. Or if there were several things wrong, they probably would have listed all of those things that were wrong. So the fact that they only asked for the letter of intent to marry, that's probably the only thing you were missing. And so as soon as you get that back to them, the next thing that will happen, which is to get back to your actual question, what happens next? What happens next is they probably reviewed everything else. Everything else is probably fine. Now they'll review your letter of intent, and if that looks good, they will probably approve it. I say probably, not knowing your case, but knowing that most of the time people are approved at the CIS. You know, most petitions that we see, and again, we're professionals and we're doing them all the time, but most of the ones we see do get approved at the CIS. When people have trouble, it typically is with a K-1 visa, it's typically going to be at the embassy stage. So having said all that, what will probably happen now, you'll get the RFE back to them. Probably within 30 days, you'll get your approval letter. Sometimes people call that the NOA too. Will come in the mail. You may also, if you file 1145, you may get a text and email. And then it'll be on to the NVC, or really to the embassy by way of the NVC. So you're probably done. It's not likely they'll ask for something else. That would be very unusual. Usually they look through the whole thing and send you one RFE with a list of all of the items they're missing. And that's a pretty simple one. The letter of intent, assuming that you did it correctly, and you probably did, then you're probably home free at this point as far as getting through the CIS. So yeah, from the time they received it, I would expect 30 days. It could happen much quicker. It really, unfortunately, comes down to the workload of the individual handling that particular case. Okay, I'll shoot the next question back to Rick in Las Vegas.
Thanks. And just to add to Ben's comments, we're seeing additional RFEs on the letter of intent where they're asking for more than just a signed letter intending to marry. I've seen a couple of cases where they want to see additional documents. They want to see wedding plans, wedding announcements, communications going back and forth, about the actual engagement and marriage. So if you're unsure about that and you'd like us to take a look at your RFE letter, we'd be more than happy to do that. You could always send it to us, contact us, because sometimes those RFE letters are vague and ambiguous at best, and so there may be something required other than just a signed letter of intent, because most folks usually send in a signed letter of intent with their initial packet, but the RFEs I'm seeing lately are asking for a little bit more, so hopefully that helps a little bit. Next question is from Freddie. He's asking, what are the top 3 Fiance Visa RFE questions in 2018? Excellent question, Freddie, and if I may, I'd like to break this down into a couple different sections, and here's why. With most visa types, we're dealing with multiple departments and multiple agencies, and what we have found in our experience is that each department has different types of RFEs, or requests for evidence. The first one that I'll touch on is the USCIS. That's where we submit the initial paperwork to, and they have a different set of RFEs that I'll go over. The primary one, or I guess probably the most popular one that I see, or most common one, if you will, is proof that the intent to marry was genuine. They want to see that you're actually planning on getting married and not just doing this for the sole purpose of getting immigration benefit. So that's when you sign the letter of intent and you provide plans of the wedding, you provide a statement or a description of your wedding plans, where you're going to get married, when you're going to get married, things like that. The second most common RFE that we've seen from the USCIS for a fiancé visa is proof of meeting in person within 2 years of filing your petition. This is a big one, and it's one that I have not seen the USCIS waiver on. If you must meet in person, you must provide physical proof and evidence that you've met in person, like photographs of the two of you together, stamps in your passport, boarding passes, receipts, things like that. And the third most common RFE from the USCIS is proof that all prior marriages were terminated. That means that you must include a copy of the divorce decree and the annulment paperwork, and you must include all pages. And probably the biggest RFE that we've seen for divorce decrees is that they are final. What that means is they've been signed and dated by the judge, and it states on the divorce decree itself, final dissolution. We've seen too many cases where they submit just the filing for the divorce, where they were not actually finalized. We've also seen some cases in states like California where they have a cool-off period, and they submitted their paperwork and their divorce decree and their petition before that date of the final cool-off period. So you have to wait out that period. So the divorce decree and annulment paperwork is very important. Another thing that we've seen, especially from the Philippines, where they have a lot of OFWs, overseas foreign workers, is that in the Philippines they require an annulment. They don't recognize divorce. So a lot of these OFWs are working in foreign countries, and they were married in the Philippines, but they decide to get married in a foreign country, then they come back to the Philippines. We are finding that the USCIS, the consular officers, are not accepting these as divorces. So you want to be real careful if you got a divorce in a foreign country where both you and your ex-spouse was not a permanent resident there or citizen of that country. Now, next we'll move on to the embassy stage for RFEs. The most common one we see there is proof of bona fide relationship. Now, that's a little bit different than the intent to marry. Once you get to the embassy stage, the consular officer is more concerned about having a legitimate relationship. And the second most common RFE we see at the consulate or the embassy is proof that a sponsor meets the minimum income requirements according to the HHS poverty guidelines, and that's based on your household size. You can check the form I-864P for the poverty guidelines, and with a fiancé visa you have to earn 100% of the poverty guidelines. With the spousal visa, it's actually 125%. Okay, the next most common RFE we see is for supporting documents. And usually those are civil documents like police certificates from foreign countries, divorce decrees or annulment paperwork. And another one that we're seeing a lot lately is police certificates with all prior names used. So this really doesn't play much into a fiance visa, but if someone gets married and files for a spousal visa, they want to see maiden names and their married names and any other married names used as well. So make sure that that police certificate has all aliases listed, because we're seeing a lot of RFEs for those right now. So hopefully that answers your question there. So we'll hand it over to Ben in Cebu.
Okay, still here live in Cebu City in the Philippines. We've got a question from Brenda. As a Canadian spouse of a U.S. citizen, I don't need a tourist visa to visit the USA. So can I visit the USA while I am awaiting my consular appointment at the U.S. Embassy? My husband and I would be driving across the Mexico-U.S. border, and then I'll fly back from Mexico. Will it come up? My passport is scanned, and I'm waiting on a spousal visa. Okay, so it sounds like you are you're Canadian and your husband's in the U.S. and you're going to drive over to the U.S. and then you're both going to head to Mexico. I assume vacation or whatever. Okay, so as far as you coming to the United States, as you said, you don't need a visa. It's perfectly legal or allowable, I should say. I'm not a lawyer. I can't speak to what's legal and what's not legal. But yeah, you can come anytime you want. Now, as we've said before, though, we have seen, especially from Canada, we have seen people turned away at the border because, to jump to the end of your question, will they see your case when they scan your passport? Yes. I don't know if in every case, I mean, we obviously haven't seen what they see on the screen there. But what we do know is that, yes, they do and they must, because we have had several times over the year. Over the years, I would say many times, people call us and say, I was driving across the Canada-U.S. border to see my husband or fiance while we're waiting on our visa, and they turned me away. Typically, this happens when you've made a lot of trips, and they start thinking, hey, you're crossing the border too often, you're abusing your tourist privileges, whatever. So that's typically the case. I would say if you haven't crossed the border in a year, you probably won't have any trouble at all. But if you've been doing it frequently, you very much might have trouble. But even if you haven't done it in a long time and they see that you have a pending immigrant visa, they may stop you. I mean, you're not in trouble. You're not going to get fined. You're not going to, it's nothing like that. They could just deny you entry, and then you got to drive back home. So yeah, that absolutely can happen. It absolutely does happen. Now we see it, a few times a year, but then again, we do thousands of these. So there's probably a whole lot of people who cross the border and have no trouble at all. And so they don't call and tell us, right? So we don't know. So I can't give you an odds. I can't tell you it's 20% chance you'll have trouble or 5% or 1%, because we just don't have those kind of statistics to know. What we can tell you with absolute certainty is people do get turned away. So it is possible. Just be ready for it. Don't start saying to yourself, hey, I'm moving there when I get my visa anyway, so let me pack everything I own in the back of this car, because then it just looks like you're immigrating. You always got to be honest with these people. Of course, I'm not saying do anything to deceive anybody, but clearly you got a guy standing there, the CBP guy, trying to make a determination. Does he feel like you're at risk of staying illegally or overstaying in the United States? If you got your car packed full of household goods, it doesn't make a good case for you. So and then as far as the second part of your question, you go into Mexico, of course, that's no problem. We don't do immigration when you exit the United States. It's probably one of the holes in our immigration system that needs to be fixed. You can leave all you want. Nobody checks you. You'll get checked going into Mexico. You will not get checked leaving the United States. I mean, unless you're pulled out for some random, they're always looking for drug cash going back across the border in Mexico or something. I mean, it's always possible. But as a general day-to-day travel process, you're not going to get checked leaving the United States. And then if you're going to fly from Mexico to Canada, the United States is not involved in that at all. It's just going to be between Mexico and Canada. So the short answer is absolutely, you can try it. You're not doing anything wrong, but be prepared, especially if you've made a lot of trips. If you make a lot of trips, which we commonly see, especially when in the case of Canada and the USC's in the Northeast somewhere, or Detroit or something where it's an easy drive, eventually they will reject you almost every time if you're doing it a lot. By a lot, I mean, every month, every 5 or 6 weeks, you're heading across the border. At some point, they're going to shut that down. They're not going to continue to allow you to do that. So there you go. I hope that helps. Give it a shot. Just be ready. Just be ready for the fact that you might get denied, and you may have to fly directly to Mexico to have that Mexico vacation or something like that. Okay, back to Rick in Las Vegas.
All right, thanks, Ben. Sandy asks, does it matter if your case is at the MVC ready for interview schedule, but you don't want to set the interview date yet because you're still gathering documents? This depends on, I guess if you're filing for a fiance visa, you actually control that timeline. You control that schedule yourself with most embassies. What that means is you physically schedule your interview online in most cases. Now, if it's a spousal visa, the national visa will reach out to the embassy and schedule that interview for you. In the event that it is a spousal visa and they do schedule the interview for you, you can contact the U.S. Embassy and you can reschedule that appointment. We have quite a few customers that do reschedule. And you can do it online, but you can also call the embassy and probably speak with an officer. Sometimes they have access to dates and calendars that you can't see, because most calendars that I've seen online usually only go out a month or two, and that's all you can see. So in your case, again, it depends on whether it's a fiance visa or a spousal visa. But if it's a fiance visa, you control that. Now, one thing you want to be cognizant of, and you want to look at your approval notice date. The approval notice from the USCIS is valid for 4 months, so you want to be careful not to go beyond that, because you want to show Department of State and show the embassy that you're still pursuing this visa. If you go much farther past that, you'll probably receive a notice that your approval notice has expired. But as long as you continue to work on the case and you're still moving forward, and what I mean by moving forward is you contact the embassy, you let them know that you're still pursuing this, but you're just held up because you're trying to obtain some documents, maybe like police certificates from foreign countries, from other countries that you've lived in or worked in, things like that. But just make sure you're in communication with the National Visa Center and the embassy. And if you're really unsure, you can always contact us as well. We can try and look up information for you, or we may already have this information, because we work with over 174 different countries, and we've processed over 40,000 of these. So anyway, hopefully that gives you some guidance and some direction, but you'll probably need to make some phone calls on that. Back over to you, Ben.
Okay. Still live here in hot and sticky Southeast Asia. We got a question from Chang. Asia, good day, Rapid. I'm so happy you were live. Hope you're both fine. Yes, we're all good. This is my concern. My fiance was married here in the Philippines, but they didn't recognize his marriage in the USA. Now he got his divorce in the USA, but he was not annulled in the Philippines. Do you think it's possible that he can petition me on a K-1 visa and he will not get a problem with his marriage in the Philippines? Thank you both, and Godspeed. Okay, so he, what I'm getting here is that he was previously married in the Philippines, and now he's divorced, and he did the divorce in the United States. Typically what you're supposed to do is register that divorce here in the Philippines. Anytime you get married somewhere else, you register that. Even when you get married, they like you to register You get married in the U.S., they like you register it back here in the Philippines. But that's the typical process. There's a couple of things here. Number one, if you're going to do a fiance visa, he's not required to get a Sinamar, certificate of no marriage. Now they can ask for anything they want, and they may well do that because they do ask about prior marriages. And so, of course, on his petition, it is going to say he was previously married, and so if they think to ask, he right now, based on what you're telling me, he would not be able to get a Sinamar because he does have a marriage on file in the Philippines, and to rectify that, he would have to submit his divorce documents from the United States, wait for them to, approve or deny or whatever they're going to do, and before he would then be considered eligible to remarry. So it's a little bit of an odd situation. We don't see this one very often. We quite commonly see, people here in the Philippines who need an annulment, or a Filipina who got married overseas and got divorced overseas but got married in the Philippines. But a U.S. citizen who got married. One thing you don't answer is if you say he was married here in the Philippines. Oh, so I guess you did say it. If he got married here in the Philippines, then and it was all done correctly, then there's most certainly a record of it. And so that's what it's going to come down to. Typically in the course of these things, the USC is not asked to provide a Sinamar, a certificate of no marriage. However, it can happen. And so that leaves you in the situation. I mean, the foolproof best thing to do would be to get those documents and register them here with the what do they call it now? National Statistics Office, it was. And then that gets the divorce on file here, and you're covered. That would be the safe thing to do. Now, would they know if you didn't do that? Probably not. But if you get all the way, you go through the 6-month process, and you get down to the embassy stage, and for whatever reason they want a Sinamar, which basically a records check on your husband to see if he has any prior marriages, and they find it. Now you're stuck. Now you're starting all over. You're going to have to resolve that issue, then resubmit your whole visa, and you've lost 6 months. And so, I mean, we're not attorneys. I can't advise you which way to go, but that's what I know about it is the USC is almost never asked for a Sinamar. It's extremely rare, which means it probably wouldn't come up, but there is a chance. And whether or not you should take that chance is not for me to say, but that's where you're at with it. The thing with divorces is because there's no divorce in the Philippines, and the end run around that, of course, is an annulment. But because there's no divorce, and annulments take years and are problematic and expensive, people have come up with many schemes to try and get around that. All the way from Sharia divorce, which normally doesn't work, to getting divorced in Dominican Republic, and all these crazy things people try to get around that. And understandably, it's frustrating that you can't just get a straight up simple divorce. So the embassies, the U.S. Embassy in Manila, they have seen pretty much all of these tricks. We always, not always, but occasionally we get somebody who thinks they're going to outsmart them. Well, you're not. They've seen it all. They're doing these all day long, every day. It's the busiest embassy in the world for K-1 visas in Manila. You're not going to come up with something novel. So what I would say is, it's always best to do it the exactly right way. Now, you're not misleading anybody. If in fact he does have a legitimate divorce, then you are divorced. So, you're not lying to anybody. In my, unlegal opinion, if you go ahead and submit it, you just might get tripped up with the paperwork if they look in there and they notice, hey, you're married in the Philippines, which is on your paperwork. Therefore, we want to see a Philippines Sinamar. If that happens to you, now you're starting over. So, the safe way is file that divorce here. And, if they were both in the U.S., if the prior spouse is in the U.S. and he was in the U.S., then it's all great and it's all great and clean. If they were in the Philippines and then he went back and got a divorce by himself in the U.S., that could be problematic because maybe she wasn't even aware. So there's some weird things that can happen. And again, we're not lawyers, but that's what I can tell you about it is normally they don't ask for a Sinamar. If they do, you're not going to be able to get one, because if they run his name through there, they're going to find that marriage if it was all done and registered correctly here in the Philippines. The Philippines, unlike the United States, does have a central marriage registry, and where all the marriages are registered. So there you go. I mean, you know, if you're looking for legal advice, I would talk to a lawyer, but that's what we know about the process. With that, I'll send it back to Las Vegas. Rick.
Okay, Heart Sweetie asks or states that I have some questions. I am from Cebu, and we are processing a K-1 Fiance Visa. Do you think it's a problem when my birth certificate has a conflict? Like my mother's maiden name in my birth certificate, she used my dad's surname, but my dad is not on my birth certificate. That's a tough question. First thing I'll let you know, on a fiance visa, your birth certificate is not required until the end of the process, until you go to your medical exam and your interview at the U.S. Embassy. The reason why I share that with you is because you do have some time to correct this birth certificate. And just to let you know, my spouse is from the Philippines as well, and we had to get some of her documents corrected. And it's my understanding that you can go to your local civil authority, civil office, and you can have these documents corrected. So if you know there's a mistake on your birth certificate, take those to your local civil office. That's like your local civil authority, government office, and take your birth certificate in there. Let them know what's wrong with it. You may have to fill out a form and submit this. But like I said, you now have the time to take care of this now, because if you get to the interview and then the consular officer issues what is called an RFE, a request for evidence for a new birth certificate, that could take some time, and it's just going to delay your case. But it's not going to stop you from presenting your petition to the USCIS and get the process started. And if you've already got it started, well, you already said you're processing a K-1, so I don't know how far along you're into the process. But I would try to get it corrected right now, because you're probably going to need that once you get to the embassy. And what we're seeing right now is that they're really scrutinizing petitions. We're seeing more RFEs now than ever. In all the years I've been doing this, I've never seen this many requests for evidence. So they're just scrutinizing everything. So I would go ahead and start working on this and getting it taken care of now, rather than take the chance, because in the Philippines, you know better than I do, it could take months to get documents back and get them corrected. So I would start the process right now in the event you did receive an RFE, and then you would be prepared for it, hopefully. But again, I would get it corrected. I've just seen too many RFEs where there were mistakes on birth certificates and other civil documents, like the MBI clearance, the police certificates. They're submitting RFEs on every mistake. So go ahead and get that taken care of now if you can. Back over to you, Ben, in Cebu.
Yeah, you know what I would add to that is that birth certificate mistakes are extremely common in the Philippines. You know, I don't know what the number is, but 20%. I mean, it seems high. We've seen everything. We've seen the gender wrong, the birth date wrong, and most common is part of the name wrong, either spelled wrong or just completely wrong. So very common. And like Rick said, you really want to get that fixed, because not just for this, but you're going to come to the United States, and eventually you're going to want to get a driver's license and all the social security number, all those things that are going to require your birth certificate. And you just want it to be right, or you're going to spend the next couple of years explaining to everybody why it's not right. And it's a whole lot easier to get that corrected while you're still in the Philippines than wait till you're back in the United States and you're trying to get a driver's license or something, and they won't do it because your birth certificate is wrong. So yeah, I would definitely go get that straightened out. It's fairly straightforward here because it is quite common. Okay, let's move on. Kenny asks, the fact that my fiance is currently pregnant and in the Philippines, does it affect her K-1 process right now? What process do I need to do when the baby's born? Well, it does not affect her K-1 right now. You don't give me any times here, and that's okay. I mean, is she due imminently? I mean, or is she going to have the baby before the K-1? I mean, these are all questions, but generally speaking, a child born to a U.S. citizen, in this case, father, so we'll say father, is automatically eligible for U.S. citizenship. So what you would do is file what's called an FS-240 with the U.S. Embassy. And it's not something we do, but, you know, you can just go to the U.S. Embassy Manila website and they have information on that. And the child is automatically eligible for a U.S. citizenship. So the child does not need a visa of any type, but you will need to file and get that U.S. passport at the U.S. Embassy. Now, there have been cases where they want a DNA test, and if so, they'll direct you on how and where to do that. Fortunately, the price of those things has come way down, and you can understand that. They just don't want people claiming babies that maybe aren't theirs. So, if that happens to you, what I would say is, it's aggravating because basically making accusations and whatever. But just be humble about it and give them what they want. It won't do you any good to argue. If they decide they want DNA, that's it. You're getting the DNA. You can jump up and down and stomp your feet and write your congressman all you want, and it won't change anything. So, and then it'll just make them hate you. So be prepared for that in case it happens. Doesn't happen in every case, but it very well may happen. And of course, make sure your name gets put on the birth certificate as the father when the child is born. That obviously makes things a little easier. So not a problem. Again, if she's still pregnant and can get here, that's great. Some of the airlines, maybe all of the airlines, have a policy of when they want to allow pregnant women fly. But there have been babies born on airplanes too. So there are plenty of airlines that aren't too strict about that. So obviously, if you can get her here before the baby's born, that's better. Unfortunately, you will not be able to expedite the petition based on the pregnancy. So, don't waste your time with that. It's not going to happen, really. I mean, if there's some rare thing, you've done an ultrasound and a doctor says there's a medical procedure that the baby needs, and, you could go down that long, winding road. But the reality is, for most of the time, you're not going to get an expedite. So that's probably not worth your time and effort to even entertain that. But yeah, don't worry about it. It's not going to change your timeline. It's not going to cause a denial. It's really not going to cause any problem at all, except that now you got to deal with this baby. If the baby's born before she leaves, then, you got to get the baby added to the visa. Well, let me back up, and I probably shouldn't have said that. That's problematic too, because a baby's born to U.S. citizen is already a citizen, and most of the times the embassy will not let you get a visa because they will say, hey, this child is already eligible for citizenship. We're not going to grant a immigrant visa or non-immigrant visa. So really the answer, if the baby's born here, is you do that FS-240. Consular's Report of Birth Abroad is the name of the form, if you all look that up. And you file it directly with the embassy in Manila. And then you give them whatever additional evidence they may ask for, which could include a DNA test. And if it does, they'll direct you on where and how to do that. But just have a little patience, and you'll definitely make it happen. It's actually fairly common. We see it several times a year, and they're always successful. So there's no chance that you'll get denied with the baby, or that it will cause you big problems. Okay, back to Rick in Las Vegas.
Thanks, Ben. Just to add one thing to that with the pregnancy, what we've been seeing lately is that the consular officers are requesting a sworn statement or affidavit from the U.S. citizen or petitioner recognizing the pregnancy in order to get approved for the visa. They just want to make sure that they are aware of it. And then it also usually comes up in the medical exam, of course, as well. And so just to throw that out there to set your expectations so that you're not caught off guard or surprised if the consular officer asks for this sworn statement. So you may even want to have that prepared before the interview, and just to make the process go quicker and more seamlessly. So anyway, we'll move on to the next question from Marta. Is there anything that could cause me to lose my green card? That's a pretty big question. There's actually quite a few things that could cause someone to have their green card taken away, or lose the green card. The first and probably the most common one is immigration fraud. If you've lied on your forms, your application, to get an immigration benefit. That could cause you to lose your green card, even if they find out about the facts later on in the process. Another big one is criminal activity. If you're here in the United States as a permanent resident and you commit a serious crime, that could be grounds, to lose your green card and possibly be deported. Fraud overall is another reason to lose your green card. Omitting information in applications, which I kind of touched on. And then the other one is abandonment. Abandonment is when someone is a permanent resident and they leave the U.S. for an extended period of time, usually more than 180 days, and they didn't notify the Department of State and they didn't request a waiver for this. If you know you're going to stay outside the United States for an extended period of time, you can actually notify the Department of State, and usually you can get this waived. But those are the most common reasons for losing your green card or getting deported. Back over to you, Ben and Sabu.
Yeah, you can get a travel permit or advance parole to stay out of the United States for an extended period of time too, if you have a reason to stay out for, I think it's up to 2 years. It's the same form you use for travel permits, I-131. So if you know you're going to be out of the country for an extended period of time, just plan in advance, file the right documents, and that'll protect the green card. Okay. Arvin asked, I'm a smoker, cigars. What would be the reason I won't pass the medical exam? That wouldn't be a reason. And first off, let me just clarify, because sometimes it comes up. You didn't indicate if you're the alien or the U.S. citizen. The U.S. citizen does not get a medical exam at all under any circumstance. So, but the alien, of course, does. And they're looking for communicable diseases. They're looking, to verify you're not a drug user. They're looking at your general health. But, if you're a smoker, it's not going to matter. I mean, it's just completely irrelevant. Even if you had, smoking, the things that can happen from smoking are not communicable. And that's the primary thing they're looking for. So even if you had some problems, some emphysema or cancer, or hopefully not, but even if you had problems, that wouldn't be a reason necessarily to deny your entry. So no, absolutely not. I wouldn't, if that's your biggest vice, you're in good shape. You're not going to have any problem. Okay. I'll kick the next one back to Rick.
All right. Julian asks, hi, I'm a Filipino working in London. My fiance is an American, and he wants to apply for the K1 Fiance Visa while I'm in the UK. Is that possible? And what's the process to apply from a country other than my home country? Well, just to let you know, that's very common, especially for a lot of our customers from the Philippines. A lot of them are OFWs, overseas foreign workers, and it's not a problem at all. I mean, we've processed hundreds, if not thousands, of cases or petitions just like yours. The primary difference there is that you have to be a lawful permanent resident. You have to be there legally. Most OFWs, of course, have a work visa in that particular country, so they're there on a legal status. But if you're in that country and you're in what is referred to as an unlawful status or illegal status, you may want to rethink that. Now, again, we're not immigration attorneys and we can't give legal advice, but if you were there illegally, you may want to go back to your home country and do this the right way. But if you're there legally, the process is exactly the same regardless of where you are in the world. Now, you will attend the interview where you're residing, where you're working, which would be there in the UK, of course. And now, if I was just checking to see on the Fiance Visa, so yeah, you'll schedule your own interview and your medical exam, whereas on a spousal visa, the National Visa Center would do that. But anyway, everything's going to be the same. It's just that you'll do it there. Now, if for whatever reason you did change locations, you moved back to, say, the Philippines or something, you'd want to change your address immediately. You can do that online. You can also do it when you're filling out the DS-160, the visa application. But you want to do that well in advance, because once the paperwork goes to the U.S. Embassy there in the U.K., and you move back to the Philippines or something, you'd have to submit a request to transfer a case, and those can be very time consuming. They can take up to 2 to 3 months. But again, the process is the same. You just want to make sure you're there legally. That's the most important thing to know, because we have had cases where folks were in a country illegally or their visa expired, and then that becomes problematic. All right, back over to you, Ben.
Okay, Ben here, still in Cebu City, Philippines. Leila asked, what caused denial even using RapidVisa? Have you had any case like that? Well, yes, we certainly had denials. Our approval rate somewhere, well, there's a lot of variables depending on what country or what visa type. We do several different types of visas, but 98, 99% approval rate. We do, of course, that means we do see denials occasionally, and there's a lot of reasons, but to run down the most common, number one, an undisclosed marriage or criminal problem could trip you up. If you don't meet the financial requirements, that's going to be a problem for you. You're going to end up needing a joint sponsor, and a joint sponsor is not possible in some countries on a K-1 visa, and so there's financial problems that can cause you to be denied. Then there's the case of where the consular officer just doesn't believe the relationship is legitimate. And, in their defense, sometimes they are not. We all know that a marriage fraud is a thing, and we don't condone anytime we suspect it. We will basically reject your case and not even file it for you. But obviously, most people aren't going to admit that. What I say to people when they ask this question, it is common, and it's understandable because you're nervous and you've got your hopes and future pinned on this thing. If you're doing everything right, you have a legitimate relationship, and you have don't have previous immigration problems, immigration fraud, deportation, illegal presence in the United States. If you don't have any of that, you're just a guy and a girl, or a guy and a guy, it doesn't matter, but you're just a couple and you've met each other and everything's legit, really don't worry about it. You're not going to have a problem. In that case, your biggest worry is, make sure you can meet the financial requirements, make sure all your documents are in order. Now, I will say, we all, us included, occasionally criticize the CIS or the government, and sometimes they deserve that. But we've also seen cases where a petition was denied and they probably did one or the other party a favor. And I'll explain that. We're all human. We get emotionally involved and attached in relationships. If you live long enough to be an old codger like me, you've had your fair share of dumb mistakes you've made based on relationships. And sometimes the consular officer is seeing something that you didn't see when they deny these, especially when they deny a foreign applicant from a high-risk country. And if you are denied, take a close look at what it is. In all cases, you can reapply. I say in all cases, if you're involved in some crime or fraud or whatever, yeah, maybe, but that's not usually the case. If you just get denied for lack of evidence, then there are options. You can, if it's Fiance Visa, you can continue your relationship, get married, reapply with stronger evidence. But even before you're denied, they're going to give you an option, usually an alternative or a opportunity to correct it with an RFE or some kind of request for more information. And so, I wouldn't worry too much about it. Now, if there's something unusual about your case that you think is not normal or could be a problem for you, then by all means ask that question here again, or call us up and we can, at least give our opinion on that for what it's worth. But if you're like most of our customers, you've got a straightforward case and a legitimate relationship, then you really don't have to worry about it. You'll worry about it anyway, and that's human nature. We all worry about it because it's a high high stress time when you're applying. But the reality is, when we see denials, there's usually a very good reason for it. And so if you don't fall into those high-risk categories, you really don't have much to worry about. And without further details, it's hard for me to kind of go in any further in depth into that. Okay, I'll kick it back to Rick in Las Vegas.
Okay, well, that concludes our live video today. Thanks for joining us, and be sure to subscribe to our YouTube channel to get alerted whenever we post our new videos. At our YouTube channel, you can also see individual questions broken out into separate videos, and check those out, and check to see if we have any questions that have already been answered. And then I'd also like to announce our winner today for our giveaway for a credit. Congratulations to Kenny Mazur on your $100 Rapid Visa credit. Please claim it by sending us a private message. Thanks again, everyone. We'll see you next time. Take care.
Bye-bye.
Thank you for joining us today. We apologize if we didn't have time to answer all your questions. However, you can always contact us by phone or chat to answer your questions. We want to remind you that Rapid Visa is not a law firm and is not licensed to practice law in any state. The hosts of this show are not attorneys. Rapid Visa is a document preparation firm licensed and bonded in the state of Nevada. If you need help with your immigration petition, check us out. We've helped over 30,000 customers from 180 countries apply successfully. Check out our testimonial library at RapidVisa.com, where we have over 1,000 photo testimonials from actual customers describing their immigration journey with Rapid Visa. There's no cost or obligation to create your Rapid Visa account. You can create your free account at RapidVisa.com/free. Be sure to like and follow us on Facebook to be notified of future live streams. Thank you, and see you next time.